Hello everyone and welcome. My name is Fred Phelps and I have the pleasure of moderating today's presentation. This presentation is a collaboration between CSW and BMS, CSW's liability insurance broker. And we're excited to be talking today about how social workers can protect themselves in our changing technological landscape. Before introducing our speakers, I'll go over some quick housekeeping. Today's presentation will be approximately 45 minutes, followed by a question and answer period. So during the presentation at any time, type in your questions and I'll begin asking them at the end of the presentation, so about 45 minutes in. We'll also be holding some live polls today, so asking you to provide feedback on certain questions by voting live throughout the presentation. Your answers to those polls are anonymous, so please participate. All information you need to know about how to rewatch this webinar, how to access your certificate of attendance, how to download the slide deck, they're all covered in the housekeeping widget that popped up when you first logged on. With that said, it's now my honor to introduce our speakers for today's presentation. Susan Winch is the Vice President of BMS Canada Risk Services and manages affinity client portfolios within the healthcare sector. She's an expert on all things CSW, insurance, and she will be guiding us through some really interesting case studies today. Andrew McKenna is a partner at Gowling WLG's Ottawa office. Andrew represents healthcare professionals in professional liability and regulatory matters, in addition to appearing at all levels of court within Ontario. Andrew represents healthcare professions in the discipline committee matters, hospital board proceedings, and before various other administrative tribunals. We're very thankful to be having these two speakers with us today, walking us through this new topic, really, social media and e-services for social workers. So with that said, I will turn over the microphone over to our speakers.
Great. Thanks so much, Fred. I hope everyone can hear me. Hello, everyone. I hope you're all doing very well this lovely and cold winter Friday afternoon or morning for some of you. Andrew and I are really happy to speak with you today about social media, specifically e-services, and how this communication platform can support you in your practice as a tool for communicating with your clients. So thank you all for taking the time out of your busy schedule to be with us today. We hope this will be an informative session and also interesting and applicable as you become more engaged with this fast-paced, ever-changing tech environment that we live in. So let's begin. Today, Andrew and I will be addressing some of the key issues, such as understanding the challenges faced by social workers when clients move to another province or territory, and how your CASW insurance plan will respond. Consideration to regulatory and licensing issues when providing e-services to clients in another province or territory, and gaining key risk management techniques to protect your client's private information, which ultimately protects you. So in this presentation, we're going to focus on both challenges and opportunities that you need to consider as professionals are no longer limited to providing an in-person service with your clients. We'll also discuss social workers' role with PIPEDA in maintaining clients' confidential records and general private information. And I'm happy to announce that you'll all receive an extra CE credit after tuning in for about an hour with us. We'll try to make it 60 minutes. So hopefully you'll find the session interesting and informative, and we encourage you to seek additional information specific to PIPEDA regulations and policies. We also suggest that you get to know your own employer's policies and procedures with social media and client confidentiality. And lastly, please contact BMS for any insurance-related questions. We're here to serve you and make sure that you choose the best coverage options to protect both you and your practice. Here's an overview of our session today. We're going to talk about risks faced by social workers in their daily professional practice. We'll talk about what e-services entails. We'll get into 3 cases, each describing a claim situation and illustrating if and how your professional liability insurance would respond. followed by how the claim would be handled from a legal perspective, and then consideration to how the claim may be avoided or mitigated. We'll focus on the regulatory considerations and PIPEDA requirements, and then we'll have a quiz with discussion afterwards. So let's begin. It's 2017, almost 2018. We live in the age of technological advancements where cars are now driving themselves. Imagine that. We no longer need to be physically present with our clients or colleagues, and many social workers offer some form of e-services to their clients, usually as a minimal and supporting element to their professional practice. Essentially, e-services are when social workers provide services to their client remotely and not in person. This can be done through video conferencing, Skype, email, apps, and other web-based communication platforms such as video chat. All of the professional behaviors from social workers to clients are the same as if the client is in direct face-to-face contact with the social worker. E-services are often known as telepractice or telecounseling or remote practice. You've probably heard them all. But for today's discussion, we're going to refer to this as e-services. Social media and its various forms and platforms, it's here to stay. Like it or not, it's here to stay. So many of you use Facebook or Twitter or FaceTime, blog, Skype, email, LinkedIn, and even text messaging on your phone. These existing and emerging social media platforms affect the way social workers communicate with clients and colleagues. It influences the way that you practice within your field. It affects boundaries between you and your client. It affects your client's privacy and what you need to do to maintain that confidential information. It also has great influence over your competencies as a professional practicing in such a fast-moving and changing social environment. So while we all need to keep up with our professional accreditations, we also need to keep current with how we communicate and engage with our clients, with consideration to their preferences and their expectations. But of course, this always needs to be in line with your employer's guidelines and practices. So definitely ensure that you know your employer's policies when it comes to social media and managing your client's personal information. Before you start engaging with your clients through any form of social media platform, make sure that you know all the settings, what settings are available, what each setting can do, and why it has that function. Consider Facebook, for example. Educate yourself with the privacy and security settings, how you can set these up and manage these settings. Personally, I would recommend taking a course on this, or have a close friend or relative who knows the ins and outs of your chosen social media platform that can spend really good quality time with you. Some platforms will allow you to create public or semi-public profiles. The semi-public allows a little bit more control and privacy. Remember, this is your professional practice, and how you manage your chosen social media platform will ultimately reflect on how you're perceived with the rest of your professional practice. One thing to note with Facebook is that it's often difficult to separate your personal profile with your professional. So for example, you may already have a personal Facebook account set up from years ago, but for your business or professional practice, you also set up a new Facebook account reflecting your professional qualifications and expertise. So for some people, this will be easier to separate these two profiles as if you're two distinct persons. For others, it may be harder to establish a separate profile. But regardless, whether you have one Facebook profile or two, you still need to take a good look at your personal profile and make sure that should a client accidentally stumble across your profile, or if they specifically seek you out, you're still perceived as a professional individual, and the personal images will not hurt you professionally or allow clients to get too close or know too much about you or your family or private life. Really, you need to assume that all information you post on Facebook or other platforms could be viewed by your clients, as well as your employers, and even future potential employers. It's also a really good idea to discuss with your clients on how they can contact you, and only use these methods. So maybe this is only through email or FaceTime or Skype for those clients who are in a different city, or it's simply just not convenient for them to see you in person. We need to be clear here that your client's confidentiality is paramount. So remember that you need to obtain consent on how you collect, use, or disclose your client's information within all regulations, which is what Andrew's going to speak to shortly. There are practice notes available on the OCSW SSW website, and one in particular that falls in line with what we've been discussing is called Social Media in Practice, Protecting Privacy and Professionalism in a Virtual World. This is written by Lee Federidge, who's the Director of Professional Practice at the Ontario College of Social Workers and Social Service Workers. I've also been in touch with Christina Van Sickle, and she's the Director of Professional Practice at the college. And she encourages all CASW members, regardless of which province or territory you're from, to check out these resources. So although the practice notes were written for members registered in Ontario, the information is quite general and could apply nationally. Okay, so if everyone's ready, let's dive into our first case study. I'll read you the case, it's very short, and ask you whether you believe your CASW professional liability policy would provide cover or not. And then we'll discuss the answer. Okay, here we go. A social worker who works independently has helped a young woman through various family situations over the years. The young woman moved from an unhealthy home environment to a couple of foster homes and was eventually adopted by a loving and well-functioning family. The young woman is now grown up and will be attending university in a different province. And she's asked the social worker to help her while she adapts to her new student life and new social challenges. So the social worker is unsure if her insurance extends to counsel the young woman via Skype. And she also wonders what the regulatory implications could be. Okay, so what does everyone think? Does the social worker's insurance plan cover her for out-of-province counseling services? I think we should take a poll between 30 and 45 seconds, and we can start now. So A, you think yes. B, you think not. Or C, it's a possibility.
Just click off it.
Where? I can't.
Just a reminder, the polls are anonymous, and as you're thinking about the poll and answering questions, please do think about what questions you want to ask as they go along and go through the case scenarios. And at the end of the presentation, I'll be asking those questions of our presenters.
Okay, we've got 30 of the 45 submitted, so 60% have answered. I'll give a few more seconds if you just want to get your answer in there, and then we'll go on. Okay. So it's actually pretty close across the board between answers A, B, and C. There we go. I guess the majority of people are saying no. This one's tricky. Yep, this is a tricky one. So I'm going to give you the answer right now. And the answer, and I don't think it's coming. Let me wait a little bit. I'm not seeing the answer come up.
I think you had the answer there. I think that's the answer right there.
Yes.
There we go. Okay, so I'm just going to flip to the next one. Okay, what are you seeing right here? Are you seeing the answer? Oh, here we go. Beautiful. Okay, so the answer is actually C. And it's a bit of a trick question because the answer can also be A. And I'm going to explain. So if this social worker is insured under the CASW Professional Liability Program, then she absolutely does have coverage to provide e-services to her clients who live out of province within Canada. However, this social worker will only be covered if she's practicing within the regulatory guidelines of that particular province. And I'm going to pass this on to Andrew to discuss this a little bit more in detail.
Okay. Yeah, thank you, Susan, and thank you, everybody, for being here. This is an issue that we deal with in our office and our offices across the country regularly. And the question is, do I need to be registered in the province upon which my client is residing when I'm providing services from another jurisdiction? Unfortunately, there is no clear answer because the colleges across Canada have not yet come to a consensus on this issue. Every province has a regulatory scheme in place, and therefore the law views that that services are provided are deemed to be provided in the location that the client is located, and this is what causes some problems. If you are to provide services to somebody out of province, the services are deemed to have been provided in the jurisdiction where your client resides, not where you are. So even if you are registered in Ontario, for example, the best practice is for you to contact the college in the jurisdiction where your client resides, so Alberta, for example, or BC, and find out if there's anything you need to do. My understanding is most colleges are requiring you to register in that jurisdiction because the services are being provided in that jurisdiction. And just as an example, the technology standards of practice, which emanate from the BC regulator, simply do address this, but simply say that you are to comply with the laws that govern electronic social work services within the jurisdiction in which the social worker is located, as well as which the client is located. So BC, without saying you absolutely have to be registered, the expectation on social workers in BC is if you're going to provide e-services, you need to be in compliance with regulations in two jurisdictions. So the answer to this is that there's no mandatory requirement for you to register in terms of official guidelines or bylaws from the colleges, but certainly it's our understanding that they're expecting you to do that. And our advice to anybody who calls us is that you need to reach out to that regulator and clarify whether you need to provide or whether you need to register or get some sort of okay from the regulator to do so. The other thing that you need to be aware of is even if you register in that jurisdiction, your own college or your own regulator may still take the position that the services you provided, even though the client's in another jurisdiction, still fall under their jurisdiction. And there was commentary from the Ontario College a couple of years ago that said you can't assume that the legislation in Ontario does not cover you providing services to someone in another jurisdiction because the language used in the legislation isn't that specific. So if a problem arose, and as a lawyer I always like to think of worst case scenario, If a problem arose and your client made a complaint, they could complain to the jurisdiction, they could complain within the jurisdiction where they are located as well as your home jurisdiction. You may be facing two different regulators looking at what happened. So as I've already mentioned, best practice is contact the regulator if you're going to be providing services out of jurisdiction, and this is within Canada, and find out what it is that they require you to do. I just wanted to touch on a couple of things to keep in mind if you are providing services through Skype or another method, whether it's within your own jurisdiction or extra jurisdiction. Most regulators now have some sort of guideline in place that gives you some direction as to what you should be taking into account. And really the big issue for providing services in this medium is making sure that you have the appropriate consent, because there are other factors you need to take into account when you're providing these services. You also need to make sure that the services that you are going to provide do not require an in-person assessment, and you need to make that call at the outset, whether this is something which is appropriate to do in this medium. And you must ensure that the service plan is in the client's needs and consistent with what they require from you. So in terms of getting consent, just some things you need to add to the list of things you would be going through with a client already in terms of getting consent. You need to know, or you need to raise with your client the issues that can arise regarding misunderstandings due to lack of visual clues, technology failure, and the benefits of the service, including appropriateness and advantages, convenience and comfort. Reasonable alternative service options. So if your client says, I'm going away or I'm going to move, but I want to continue with you, it's contingent on you to say to them, well, you can also follow up with local services available to you. Those are options as well, in addition to providing you with the e-services. You have to talk about privacy with them because, as we all know, we can try and make our communications as secure as we can through encryption, through password protection, but nothing is foolproof. And the client needs to understand that there is a risk of communications being intercepted intentionally or unintentionally. And obviously you need to be aware of the limitations of whatever medium you are using. Just a couple of other things, and then I'll turn it back over to Susan. We've been asked in the past whether you need to record. If you record the session by phone call and video conference, and our answer is yes, you should. You should treat it the same as you would any other session or appointment with a client. You take notes, but if you can record it, that's also helpful in terms of being able to address any issues that come up afterwards, any follow-up questions, etc. And the last thing I want to talk about is making sure you have a system in place to deal with a situation where you lose the call or you lose the connection. What happens? And you could be dealing with somebody who's in crisis, and what happens if you lose the connection? If you're going to do e-services, then you should have a backup plan in place. So if the video link drops, you have a phone number that you can contact them at right away. Or you should have a backup person in that jurisdiction available to take over if there is a problem. Or if you determine at the end of the session that they need somebody to deal with it right away, you can follow up with that.
Okay. Wow. Thank you. That was great. Okay. Let us continue on to case study number 2. I'm going to do the same thing. I'll read you a case scenario and ask you whether you believe your CASW insurance plan would respond or not. Okay. Mary, a social worker and clinic owner, regularly meets with a retired accountant, Bob, who's battling alcoholism. Mary meets with Bob once a week. However, Bob has the opportunity to join his brother and family in Florida for the month of January. And he's concerned that without Mary's counseling, he may be unable to manage his anxiety issues, and he may possibly fall off the wagon. Bob has asked Mary to provide counseling services during this time away by Skype or email or phone, whatever it takes to help him while away from his regular activities and environment. So the question is, should Mary accept Bob's persistent request to maintain their sessions while he's in Florida? So we'll take a poll and see what everybody thinks. A is yes, she definitely should. She has a moral responsibility to her clients. B, no, she shouldn't. The policy's territorial limits do not extend beyond Canada. Or C, possibly. So let's take 30 to 45 seconds and think about that one and just make an answer, put down an answer, and we'll talk about it.
I'm interested in the answer of this one because this is a question that we often get here at CSW.
Yeah, it's a good one. It's an important one.
Continuity of care versus international jurisdiction. So looking forward to the lawyer answer on this one.
Well, so far the answers are pretty split between A, B, and C. Why don't we give, just a few more seconds just to, we got 72% polling. Maybe we can just get everybody to put in an answer, like in the next couple of seconds. Okay, let's see how everyone has answered. So it's pretty close. The majority have said no, which is B, followed by possibly and yes. So I'll give you the answer. The answer is actually A, yes. Mary should definitely feel free to continue her sessions with Bob while he's in Florida or anywhere worldwide. So just to let you know, Mary's CASW insurance plan provides worldwide e-services cover. So she can continue her practice with clients during their time outside of Canada, provided, one, and I'm just going to flip the switch here so that you can read this along with me. There we go. The provisions are, one, Mary is rendering her practice within Canada. So she's in Canada. So her client may be anywhere else in the world on vacation or doing whatever, and she's providing services, but she needs to be rendering her practice within Canada. And two, her client would have to file the action, the suit against her in Canada or the U.S. So those are the provisions, and those are the only provisions where the policy would trigger and provide cover. And from here, I'm going to pass it off to Andrew, and he's going to discuss, how to put in a claim and all that good stuff.
Yeah, thank you, Susan. And a lot of what I said to the answer to the first scenario applies here, in that if you are going to continue to provide services to somebody who is in a foreign jurisdiction, again, you need to make sure that you are in compliance with whatever regulations and laws they have in place. In Canada, you can take some comfort that while there are little differences between the provinces and the territories in terms of what's expected of social workers, generally the same set of guidelines and expectations apply. I can't tell you that that's the same for states in the U.S. or worldwide. There may be some very different things that apply. So if you're going to continue to provide services, please make sure you do your due diligence and look into what is applicable to you and whether you need to get any type of clearance. If you find yourself in the position, and I think a lot of people do, that you don't feel comfortable providing services to somebody that's going to be away for 3 months in Florida, for example, for the winter, then you still have an obligation to ensure that there's no break in the continuity of care. So if you do have a client that's going away, you want to make sure that the arrangements are made that they can continue to receive the care that they need. And that could be reaching out to see if somebody can assume their care, assume their sessions while they're there. That's an obligation you have as a social worker through your regulator, that you need to make sure, and it's not saying you have to do all the steps, but you need to satisfy yourself that your client is going to receive the care they need while they're away. So keep that in mind. Should you decide they're leaving jurisdiction, leaving the country, I don't feel comfortable doing this, make sure that you've satisfied yourself that there is something set up for them. Just in terms of claims, one of the things I would be considering when deciding whether to provide services, again, outside of Canada, is whether you would want to subject yourself to a claim in the United States. As Susan's already mentioned, that if a claim is started in the U.S., your insurance will cover that, and that's great. But anybody who watches TV and listens to the news will hear of big settlements and big decisions from courts in the United States. Courts in the United States tend to, in some jurisdictions anyway, tend to award much larger amounts than they do in Canada, and it's just a way, there's a difference between our system in Canada and the U.S. in terms of size of awards and expectations on healthcare professionals. So you may want to keep that in mind. In this particular circumstance, if there was a problem, if something happened to Bob while he was in Florida, he could choose to sue in the United States, he could choose to sue in Canada. It would be up to him to where he wanted to start the case. And if you were sued for something that happened while he was away, then your legal counsel would determine whether you would want to challenge that jurisdiction and try and move the case to Canada or to the U.S., depending on what was applicable. So, as Susan said, as long as the case is started in the U.S. or Canada, you're covered. So give pause to think about whether you have somebody going overseas, whether you want to continue that, because there's nothing telling that person they have to start a claim in the U.S. or Canada. They could start it wherever they deem necessary, and you would have to consider that in determining whether you're going to provide those services.
Okay, well, thank you. All right, let's move on to case study number 3. This is the last scenario. Okay. So Glenn is a school social worker at Parkside Elementary School in Grand Prairie. He's been working incessantly on a family counseling plan for one of his students, Susie, who is a bright-eyed 8-year-old with absolutely loves to draw and color scenic images. But she's incredibly shy and finds it very difficult to find friends and communicate with others. Glenn will be meeting with Susie's mother tomorrow morning at 10, just for an hour, before Susie's mom has to be at work for a shift at the hospital. Glenn has a great plan in mind, which should work in line with the mom's shift work, but he really needs to work on this at home tonight and then print the plan out at work tomorrow morning prior to his meeting. Unfortunately, when Glenn arrives at the school the next day to print out his program, he realizes that somewhere between his house and the school, and 30 kilometers in between, his USB stick is lost with very personal information on Susie and her family, as well as various names and sensitive information and assessments of prior students and families that Glenn had counseled over the years. And he thinks about it, the USB stick also referenced the name of his school and the teachers for each of his clients, along with their own regular comments. So, what does Glenn do? Who does he turn to for help? All right, so let's think that one over. We'll do a poll on this one as well. So A, Glenn should meet with Susie's mom as planned and wing the program from memory, which he hopes she'll support, and advise that he'll send her an electronic copy within the next day or so if she wishes to proceed with the program. Or B, Glenn should advise the school's principal and discuss the situation right away, and then meet with Susie's mom and explain why he doesn't have a hard copy program for her. Or C, Glenn should call in a sick day and walk the 30-kilometer route back to his home to search for the lost USB stick. Okay, what does everyone think here? Let's give another 30 to 45 seconds and think this one through. Really interested to see how people vote on this one. Okay, let's see. Okay, well, not everyone has voted yet, but we're seeing consistency within a particular answer.
Yeah, I think that's perfectly fine. We can head away. The time's slipping away on us, so we'll see.
Okay, I'll move on. Yeah, all right. Okay, so almost all of you have chosen B, and I think you're absolutely right. B is the winner, and maybe even C in there. So for those of you who answered both, you got that right, you got the point. So in this situation, Glenn needs to meet with the principal ASAP and advise what all is on that USB stick. Names that could be implicated, if it's in the wrong hands, potentially disclosing personal information. Then the principal would call his broker, BMS, and let us know the situation, that there may be a potential claim here. We would then make a call in to the cyber liability insurer, who is Beasley of London, and the insurer would then reach out to the principal and respond to the breach. So now I'm going to pass it off to Andy, who's going to speak on PIPEDA regulations and how the school's compliance policy could potentially incorporate to align with the PIPEDA.
Okay. So just to follow up on the answer, and absolutely, Glenn should be speaking to the school about this. And when you have a potential or a privacy breach or a potential for a privacy breach, you need to think about what your role is first. And in most jurisdictions, and I speak from Ontario because that's where I'm located, but I know most of the other jurisdictions have the same general policy in place. Are you a health information custodian, or are you employed by a health information custodian? And the steps that you take are generally the same, but you just have to determine whether you're the one responsible for the records or whether somebody else is and you have accessed them by way of being an agent of that HIC. So Glenn should bring that to the attention of the school board, and the school board should have a policy in place to deal with that. But one of the things that absolutely has to happen in a situation like this is that you need to be proactive in getting the your jurisdiction's privacy commissioner involved. In Ontario, it is mandatory now to report any privacy breach to the Information and Privacy Commissioner. In Alberta, where this situation arose, it allows for the reporting of incidents involving the loss of unauthorized access to or disclosure of personal information where a reasonable person would consider that there exists a real risk of significant harm to an individual. I can tell you in practice that the failure to act proactively and immediately in reporting a privacy breach can lead to all sorts of problems, not only with the privacy commissioner, but also with your regulator and potentially civilly. So as hard as it is to report something like this, the consequences to you, if you are the health information custodian, or your employer, and that includes you as the employee, if reports aren't made immediately, can be dramatic. So you need to be aware of those obligations. Susan mentioned PIPEDA and PIPEDA, and I know we're running short here on time, and I could do a whole hour on the intersection of these two acts.
Can you actually say the long version of the acts you're talking about?
Yeah, sorry, thank you. I talk like everybody knows what I'm talking about. So PIPEDA is the Personal Information Protection and Electronic Documents Act. PIPEDA is federal legislation, and that applies to private sector organizations. Then we have the PIPEDA, and that's Ontario only, Personal Health Information Protection Act, and that deals with health information which health information custodians have access oversight to in Ontario. And there's an intersection between the two acts. In Alberta, in this situation, we have the Health Information Act, which applies, Personal Information Protection Act, Freedom of Information and Protection of Privacy Act. Those are all acts that would come into play with this type of breach. So thankfully, most provinces, privacy commissioners and offices have lots of guidance on what to do if there's a privacy breach and how to deal with it. Just the last point in terms of making sure that your policy gels, your internal office policy or your employer's policy gels with the legislation. Just some steps here, and I'm happy to circulate these, but you want to designate somebody in your organization as the contact person when this type of thing happens. You want to have some consistency there. You want to have an inventory of the information to be covered by the privacy plan. You want to identify the purposes for which you collect, use, and disclose personal health information. You want to develop practices regarding safeguards, retention, and destruction. You want to develop practices regarding access, correction, and complaints. You want to have a protocol in place for privacy breaches so everybody knows what to do when something happens. And then, of course, the last step is to implement that plan and have it in place. And I'm sorry I'm so short on this area. There is a lot, but like I said, of the topics we've covered here today, that last topic in terms of privacy information, there is lots and lots of information out there on the web. And of course, if you ever have a situation where you need some advice, you can call the pro bono hotline that we operate out of our office for some guidance, and the lawyers that staff that hotline will be able to assist you with, obviously, with a case-specific question.
And just to add to that, as an FYI, CASW members can purchase cybersecurity and privacy liability for $75. And for businesses, it's a minimum of $480 on the program. Excuse me. And this includes $1 million limits of privacy breach. That includes regulatory and defense expenses, cyber extortion, notification expenses such as costs involved with notifying all affected individuals, the cost of a call center, cost of PR consultants and credit monitoring for a year, that sort of thing. So it's a pretty good piece of cover to have for a small amount. And depending on what you're doing and you know what platform you're using, you may or may not need or choose, but the coverage is available, so I just would like you to know that.
Excellent. And over and above that additional coverage, CSW is very proud that our liability insurance through BMS, I believe, is the only liability insurance program in Canada for social workers that covers e-mental health services. So very thankful for BMS to extend that liability to us. And I really do want to thank Susan and Andrew for presenting to us today on this topic. It is a new and emerging topic, the topic we deal with every day, and have questions to navigate through that. And speaking of questions, this is the question and answer time period. We're going to go about 15-20 minutes into questions. There are a ton of questions here. I think the scenario has worked very well in the sense of spurring people's thoughts. I did get a good couple giggles of Glenn's. There's a few comments, not necessarily questions, but from Glenn's scenario, especially one person said, I would be walking up and down and calling in sick and trying to find that USB. I found that quite funny. And the other flip side of people going, surely you wouldn't be advocating for someone to call in sick and to try to find the USB. So I found that just kind of on the humorous side, but on the more serious side, I think Bob's scenario brought in, I think, a lot of questions for the audience. And I think without asking a direct question from people, I'm just trying to go off what 4 or 5 people have asked. And I think there might be some confusion between, I think because of Bob's scenario, there was a kind of alluding that you could work with Bob in the U.S., but if Bob was if I was working in Saskatchewan and Bob moved down to Arizona, I could provide him services, but if he moved to Manitoba, I wouldn't be able to do so. And I think there might have been some confusion in the sense of whether someone was away from the country or away from their home province for a short time period versus residency. So I would probably ask Andrew just to clarify in the sense of the provisions of services in another jurisdiction.
So, and I apologize if there was confusion. I think that the answer is the same. Is out of jurisdiction, whether it's another province or another country, I think the same logic and the same principles apply, is that you are able to provide services to somebody in another jurisdiction, whether they're there for a short period of time or whether they're there as a resident. The issue is you making sure that you're in compliance with whatever the applicable regulations and standards are for social workers in that particular jurisdiction. I think I was trying to differentiate between Canada and the U.S. in that most Canadian jurisdictions have very similar guidelines in place as to the expectations for social workers, where I can't say the same for the U.S. So you can provide e-services in another jurisdiction, subject to you satisfying yourself that you meet with all the regulations and guidelines in place in that particular jurisdiction where your client resides.
Yeah, so I think this question is from Carmen is along the same lines, but I think it's more in the provision of services as a provider. So she says it sounds like we can see clients as outside of Canada, but we have to be in Canada. So if I was a provider in Arizona for the winter, I couldn't work with my clients in Canada. I wouldn't be covered. Correct? If I'm a snowbird and I'm a social worker in British Columbia and I go down to Arizona for 3 months of the year and I'm working out of Arizona, I couldn't deal with my clients in Canada because my practice would have moved to Arizona.
Yes, and you presumably have to be licensed in Arizona and then abide with whatever rules they have to provide services extra-jurisdictionally.
Okay, perfect. Thank you very much. This is a very good question. I haven't seen this one before. As a private practitioner, so I think it's referring to to Glenn's scenario. As a private practitioner, who would I report a security breach to? My insurance company?
Yeah, absolutely, he would. I mean, this in this particular situation. He caused the breach. However, it involves, his clients, but also with respect to the school and the principal. So that's why that's his employer, basically. So under the employer being the school, who owns that personal information.
They're the custodian.
Yeah, they're the custodian of the information. They need to report that to their insurance company.
But you as a member, you need to make sure that you've made, let's say the school board, and I don't think this would ever happen, if the school board didn't have a policy in place for dealing with a privacy, you would need to satisfy yourself that the school board was taking the appropriate steps to report it. even though you're not the health information custodian, the employer is, but you would still need to satisfy yourself that they were. And I say that just so that you're protected, should there be a complaint to your regulator down the road, you can say, I advised my employer of this, and they said they were going to take care of it, and I left it to them to deal with it. And I put it in writing or whatever, however you chose to deal with it. But you do need to make sure that they are made aware of that obligation.
Okay. Just to confirm and to clarify, someone's asking, does BMS provide coverage across the whole of Canada, and does it cover social work services or e-services being delivered to the U.S. or even other parts of the world? So our e-mental health service coverage.
All right. So the insurance plan covers the insured, the professional social worker, while they are practicing anywhere within Canada. They can provide these e-services to their clients anywhere worldwide, but they need to be practicing here in Canada. Doesn't matter which province, which territory, they need to be in Canada. And then if and when if a suit is launched against them from one of their clients who is abroad somewhere, their client would have to launch suit within Canada or the U.S. But it's really important that the insured maintain their practice, their e-services practice, within Canada.
Okay.
Does that answer the question?
This is an interesting one, and I think this is one maybe, Andrew, you can speak to. More and more, I think servers and the cloud and things are not necessarily confidential and not necessarily servers that are within Canada. So the question is, when we've researched providers for e-services who discovered that Skype is not confidential as they own the conversation. Can you speak a little bit about the differing technologies and kind of the dangers of privacy in this regard?
Sure. So just so I heard the question right, so the discovery that Skype is not a secure medium.
Yeah, and that Skype owns that conversation, typically like similar
right.
to if I'm in a Facebook conversation or a Facebook post, I might think that that's actually my information, but it's actually Facebook.
It's not. It's Skype. Right. Okay. So that's a good point to raise. So in terms of, and that goes back to my comment about understanding limitations of whatever technology you are using. So the different mediums that are in place, the clouds, etc. You've got to work with the assumption that none of them are 100% secure, and I said that already. In terms of there being a breach, I think you have to, if you're going to use Skype, for example, you need to let the client know that while we're talking on Skype and it's a conversation between you and I, that the conversation itself may be recorded, and that you need to understand that that's a limitation of this technology, and it's something which I, as the service provider, don't have complete control over. So as long as the client is made aware of the limitations of the medium, then you're protecting yourself as a social worker in terms of any claim that may be made against you down the road. I mean, for email, we all use email to communicate and send documents. You should never, ever be using email to send personal health information. And even password protection, so you send a document that's password protected, the Information and Privacy Commissioner has deemed that that's not sufficient for the protection of information. We use a secure encrypted email in our office to send personal health information that somebody can go and grab the documents from an encrypted server. And I mention this because there's lots of people that, there's even some colleges that use password protection on documents, and that, best practice would say that's not sufficient. So know the technology you are using, know it well, and know its limitations.
Wow, that's very interesting. I think there's a whole webinar there on privacy protection there, I think.
Absolutely.
Not that I'm doing a product placement, but there's an individual that says that from their experience, WebEx is secure. I think this question is for you, Susan. If you provide e-services to someone in Australia, and they start a claim there, so meaning in Australia, is it correct that BMS would not provide coverage?
Sorry, the client is in Australia, and I missed a little bit of that.
So if you provide e-services to someone in Australia, so ostensibly I think this individual is in Canada, so you provide e-services to someone in Australia, that individual starts a claim there in Australia, is it correct that BMS would not provide coverage?
That's correct. The policy would not trigger, the suit would have to be launched and filed within Canada or the U.S. So that client would have to make the trip to do so if they're filing suit, and you clearly would need the policy to trigger and cover.
So they would have to, that individual would have to file here in Canada to trigger BMS.
Right, that's right.
Now, I'm maybe this is an Andrew question. If a claim is done in Australia and I'm not in Australia and I'm in Canada, can I be held accountable legally in Australia?
Well, I'll qualify my answer in terms of not being on top of the laws in Australia, but generally speaking, because if I work on the assumption that the laws is the same in Australia as it is in Canada, and Australia is a common law jurisdiction, that services are deemed to be provided in the jurisdiction where the client resides, then if an Australian court determines it has jurisdiction over the issue, then yes, you could be deemed liable for any damages that are caused as a result of negligence on your part. I mean, what would normally happen is if you're here in Canada and you provide those services and you get sued in Australia, you're going to retain counsel, you're going to retain Australian counsel, and they're going to determine whether the court has jurisdiction there or whether the claim's more properly brought in Canada. And we call it conflicts of law. You often have different jurisdictions fighting over who has jurisdiction over a particular claim. That's based on where the client's located. I would say that there's a good possibility an Australian court would say they have jurisdiction. There's other issues that flow from it as to whether they could enforce any type of judgment against you because you're in a different jurisdiction. You're in Canada, so money was awarded against you. Could they actually collect because you're in a different jurisdiction? Those things come up as well. But short answer to your question is yes. If you're sued in Australia and the court determines it has jurisdiction, then yeah, you could be on the hook.
Well, there's and there's nothing against our presenters. You guys are navigating this very well, but as I get deeper into this thing, it either gets more clear or more confusing.
More
scenarios, and I think as we move ahead, especially as a national association, this needs to be something on our radar, looking at e-services, and maybe possibly we need to do some work on what's required in each province and territory for registration, especially when you're delivering e-services, that type of thing. It's certainly an emerging issue, and think something on a national basis we need to look at. So I have a question here. We got a few more minutes. I might go past 2 o'clock just a little bit, and thank you both for your time. If I was away, Corinne is asking, if I was away to like 2 to 6 weeks in another country or 2 to 4 weeks in another country, can I provide services if needed on an emergency basis? On various ongoing therapy. I think meaning if she's on vacation 2 to 4 weeks and she has some ongoing clients, can she be in that country, sitting on a beach in Cuba or another country, and provide those services?
That's a really good question. Right now, as a policy, I mean, there's nothing endorsed any differently. So the short answer is no. You're away in Cuba. You're outside of the territorial limits of Canada. You're providing services. You're communicating. The policy.
Yeah.
Respond.
Yeah. And there's 2 different answers here. There's an insurance answer and there's a legal answer. Insurance-wise, I leave that to Susan to tell you whether you'd have coverage. In terms of your obligations, if you've gone away for 6 weeks and there's an emergency situation with one of your clients, and if you have not made arrangements before you've left on what to do in an emergency, then your college could presumably say that you do need to deal with this. it could be as simple as tell them to go to the emergency department, or I've got somebody that's agreed to cover emergencies for me, get them to go see that person. But you do need to make sure you've got something in place if you are away and you do have clients, which there may be an emergency, and if it means having to spend some time on the phone while you're away, then you need to do that. Understanding, though, that if anything arose out of it, your policy may not respond to it. So it's a good message. It's a good reminder that if you're going away for an extended period of time, you should have arrangements made to deal with any emergencies that come up while you're away.
You know, I love social workers because social workers are always looking out for each other and looking at self-care. And the next person right up the thing is, my question, why is a social worker? She's on vacation. Why are you communicating with clients? You need a vacation. Quite nice. So I work as a telephone counselor for an EAP and provide client services to services to clients all over the world. I have an insurance in my policy that covers me. Do I have to be registered with the respective college social work in each province where my clients are located? That would be 10 colleges. And I think this circles back right to the very beginning of this presentation. And I think this is kind of the gray area, and I think where the intersectionality between the legal, regulatory requirements and the coverage of liability insurance all kind of intersect. And I don't think you're probably going to be able to give a definitive answer, but your best answer on this, Susan and Andrew.
I can go first. My best answer would be is that you need to contact all 10 jurisdictions and find out what they require from you. You cannot assume that you can provide services in that jurisdiction if you're not physically located there without at least checking with the regulator to see whether they require you to register. Susan and I were talking about this before we started, that another profession, they have like not a temporary license, but something in place for somebody that is providing services on a temporary basis, that you pay a small fee to the regulator to be registered just to cover off for a short period of time. I haven't seen that. I'm not aware of that in the social work area. I stand to be corrected on that. But I think it's onerous to have to do it in 10 jurisdictions. But because this is an area that is under the sphere of provincial jurisdiction, every province likes to say what people can and can't do in terms of that practice. So the best practice is to contact all 10 and find out if you need to be registered or not. And I think you're saving yourself some aggravation down the road by doing that.
Absolutely. I agree 100% with what Andrew has said. So your insurance policy provides national coverage for you wherever you are in Canada, but you still need to provide your services according to the provincial regulations. And each one could potentially be a little bit different. So, yeah, you need to check out what each province, what each regulator requires, and speak to the registration department. Maybe there's a registration fee, but essentially speak with each one and be sure that you've done your due diligence.
Yeah, I'm getting a few notes, and it's been well noted for myself is that we as social workers in Canada need a resource, one place to find out what each jurisdiction requires and should be kept up to date as things change. Can CSW provide that? Yes, we can. I cannot give you a timeline when we'll pull that together, but it's very clear from this type of conversation that providing a document that at least gives people avenues or an understanding of the regulatory landscape, the legal landscape, and then what their liability insurance covers. So I'm cognizant of time. I want one last question here, and I'm very apologize for those that I didn't get to your questions on. And the question is, I think, since the advent of e-services, e-mental health services, e-social work services, and technology, what has your experience been on the incidence of complaints against social workers pertaining to e-services? So I guess in terms of complaints on e-services versus complaints of in-person services, have you seen what's the landscape? What numbers are we looking at? What is the risk that we're getting involved with? What are the precedents across Canada? And we'll just kind of wrap it up after this answer.
Okay, so the short answer is we actually haven't seen a lot at all. Where we're seeing, and this is not just for. Firstly, thankfully, there's not a lot of complaints that we get for social workers as compared to some other professions, which is a good thing. Second thing is that we're actually seeing more issues, and this is across the board, not just for social workers. This is across the board. More issues with the use of social media as a tool to comment about issues within the profession, comment about your experiences, blogs, for example, Facebook postings, where things have been said that have either explicitly been critical or been interpreted to be critical of other members of the profession or of certain policies. And the colleges across Canada are taking a rather dim view of members who engage in that activity. There's a case out for some of you may have heard about this case in Saskatchewan with it's a nurse who commented on Facebook about the care her grandfather received at an institution, didn't call anyone out by name, simply expressed her frustration. A complaint was made, and she actually went to discipline and was disciplined by her college for making those comments on Facebook. That's under appeal, and hopefully the appeal court will overturn that because it's a real concern in terms of somebody's ability to speak their mind and free speech. But it is a concern, and we are seeing that. But that's more of the issue in terms of e-services, use of technology. In terms of e-services, it's always issues surrounding consent. Have you appropriately provided the patient or client with the information so that they can consent to the service that you've provided? But honestly, we haven't seen a lot of it yet, and I think it's just because it's new. As we go forward, I suspect we're going to see more of it.
All right. Well, with that, Susan and Andrew, I thank you very much. I learned a lot from the great examples and the presentation. For those who require it, confirmation of attendance, so those in the audience, the confirmation of attendance is now available by clicking the yellow icon on the bottom right of your window. With that, again, a sincere thank you to our speakers, the audience, and your questions. I'm sure this will be an issue that we may look at on an ongoing basis moving forward, because I think the landscape will somewhat shift and change pending on legal, regulatory, and liability coverage. I thank everyone for attending. Happy holidays to all, and we'll see you all in the new year.
Thank you.
Thank you very much.